we're going to ask, yes, Leann to introduce Christine. And Christine is from an environmental lawyer, but we'll hear more about that from Leann. Over to you, Leann.
Thank you, Carol. And firstly, I'd just like to acknowledge that I'm speaking from the beautiful lands and seas of the Ramangeri people of the Ngarrindjeri Nation, and pay my respects to their elders past, present and emerging, but also to say that, you know, they're the people we should listen to about the way that they cared for and looked after the environment so very well over very many generations. So it's my absolute pleasure today to introduce Christine Trenorden. She's from my club, the Zonta Club of the Fleurieu Peninsula, and I think we're indeed fortunate and benefit from Christine's vast experience in environmental resources, in development and in planning. So throughout her career as an environmental and planning lawyer, she's also been a judge in the District Court and a specialist and in the Court of Environment, Resources and Development. Christine's been concerned with ensuring that legal frameworks and policies around land use, planning and environmental protection from both pollution and biodiversity conservation, and it's appropriate and also has done a lot of work around ensuring that lawyers, judges and enforcement officers understand their roles and have relevant knowledge and skills around that area as well. But beyond this, Christine is really passionate about human rights and environmental justice and the importance of a safe and healthy environment for everyone. And this can be seen in her work in areas of native title, in anti-discrimination. She's also worked in Indonesia and elsewhere to support and improve the concepts of environmental law. And she's been mentoring environmental lawyers in the Pacific Islander nations and supporting and strengthening coastal and marine resource management. Amongst her many achievements, Christine has held positions on committees and boards. She's had teaching positions at universities and volunteered for her community. Christine is currently a board member of the Environmental Protection Authority South Australia and an independent chair of the Alexandrina Council's Climate Emergency Advisory Committee. So please join me in welcoming Christine Trenorden.
Thank you, Leann, for that rather fulsome introduction. Today I was asked by Carol just to talk a little bit about my climate journey, in particular in relation to, well, with a particular focus on biodiversity. I have prepared a presentation which is mostly pictures, but it's for something to look at other than my face while I'm talking. So I'll now go to share my screen. Sorry, I haven't done this for a long while, so bear with me. Now. Oh, sorry, I think I did something wrong there. Let's start again.
Just the big green share screen should do it.
Yeah. No, I'm doing something wrong.
Don't worry, at the bottom of your screen, have you got the...
yeah, I've got that, but it's just bringing up the PowerPoint.
Okay, so... yeah.
No.
There we go.
Oh, good.
You're there.
Relief. Sorry about that. So at first, when I was growing up, I suppose I was introduced to the nature of our environment on biennial trips to Sydney to visit Mum's parents. So we'd drive across and I got to understand the different environments in our country. But I first really became aware of the natural environment, in particular the flora around me, when we lived in the Adelaide Hills when I was a teenager. I was a bookworm, so I didn't actually go outside much, but I did. When I did, I loved to go into the bush block of the property, and I was fascinated by the native orchids, terrestrial orchids of the Mount Lofty Ranges. So I thought you might enjoy some of those photos with me. My approach to the protection of biodiversity of flora and fauna has been informed by the experience in living in different climates, different natural environments, including the lush tropical environments of Papua New Guinea and Fiji, as well as the drier temperate climates of South Australia and Western Australia. And I also, as you heard from Leann, worked in various places in the Pacific Island nations and in Indonesia and Laos over time. So I've experienced, in the sense of spending some time there, I've experienced a variety of environments. On reflection, once I became a lawyer, I think I was always keen to use my knowledge to make a difference with appropriate laws and policies to help protect the natural environment and courts to enforce them. Well, how could we do that? One way was to advocate for the appropriate laws. A second was to educate the community and clients and other lawyers to help change attitudes towards the natural environment. And a third way was to widen access to the courts to stop acts and activities, just like Alana's group has been doing, that threatened the destruction of or destroyed the natural environment. During my work as a barrister and solicitor, I was involved in a wide variety of matters concerning the environmental impacts of development proposals, the legality of the clearance of native vegetation, and whether development should be permitted in what were then called national parks. It seemed important to me to research and advocate for legislative change in all aspects of the protection of the natural environment. And a number of us did that through multidisciplinary associations such as the South Australian Environmental Law Association and then the National Environmental Law Association. I say multidisciplinary because they weren't just lawyers. There were also planners and scientists from a variety of backgrounds, particularly in relation to native flora and fauna, botany and so on. This was a time of cultural change, and I'm talking early 1980s. In that period, it was still the case in South Australia at least that the conditions of a Crown lease for pastoral activities, for example, required the clearance of a certain percentage of native vegetation every year. Can you believe? The concepts of vegetation or habitat corridors for wildlife, heritage agreements over the parcels of private land, and the establishment of offsets, just for some examples, were only just beginning to be recognised as a means to protect native flora and fauna species in that period. Indeed, the realisation that Australia was losing species at an alarming rate was only just happening. In this period, the mid-1980s in South Australia, just to give you an example, South Australia did not have the sort of forests that Alana's been talking about. South Australia only had 10% of its original native vegetation. So much had been cleared. Anyway, what to do? With others, I was active in advocating for a specialist environment court comprising both judges and experts in particular relevant fields, so an interdisciplinary court with jurisdiction to hear appeals in relation to development decisions, to issue stop work orders where activity was detrimental to the environment, or that kind of activity was being threatened. And that's a really important distinction, as well as charges of offending against the legislation we did have for protecting the environment. I should say this was also an interesting time because we, at a global level, we had had the Brundtland report delivered by the World Commission on Environment and Development. Of course, the Brundtland report is what we all know as the book, Our Common Future. And I've put on the slide there one of the principles, number 3, from that report in relation to the conservation of biodiversity. It was an exciting period as we moved from the 80s into the 90s. In 1992, we had the benefit of the first United Nations Conference on Environment and Development, also known as the Earth Summit. I've put a photo of the leaders, world leaders, present at that conference in Rio de Janeiro, 1992. I strained to find the women leaders in that photo. I counted 2. Good luck if you can find any more than 2. At least things are a little bit better today. That conference produced the United Nations Framework Convention on Climate Change, the Convention on Biological Diversity, and the United Nations Forest Instrument, as well as Agenda 21, the agenda for the world for the 21st century in relation to environment and development. In Australia, what was happening? Well, in the Intergovernmental Agreement on the Environment was entered into between the Commonwealth, all states and territories, Western Australia last, I have to say, and the Australian Local Government Association. Now that was a signal event, and also by the end of, so we have Rio de Janeiro in July 1992, and in December 1992, we had the National Strategy for Ecologically Sustainable Development produced. So exciting times for lawyers who were passionate about protecting the environment. And we were all doing a lot of work, holding a lot of conferences, having a lot of meetings nationally to encourage governments, both at Commonwealth and state level, to adopt laws and to also embrace the concept of specialist courts for environmental matters. South Australia decided to establish the specialist multidisciplinary Environment, Resources and Development Court in 1993, and I was appointed as one of the first judges of that court and later became the senior judge in the court. At the outset of the court, which comprised both judges and commissioners who were, some of them were planning commissioners, some of them had expertise in conservation matters, some were engineers. We had a variety of experts we could call on as commissioners. When the court was established, we had jurisdiction to hear matters under the Development Act, the Native Vegetation Act, the Water Resources Act, the Soil Conservation Act and the Waste Management Act, and later when it was enacted, the Environment Protection Act, and also in due course in 1996, I think we got jurisdiction to hear native title matters as well. In my time as a judge, I both heard and determined and mediated matters, including in relation to aspects of biodiversity. Some of those that I recall involve the likely impact on marine species, habitats, and the coastal environment of aquaculture developments, tuna farms, oyster leases, and so on. Whether remnant native vegetation, including stands of threatened species of eucalypts, should be cleared for land division for residential development. The impacts on native vegetation and bird life of the development of vineyards, the impacts on the natural ecosystems and native fish of dam construction, and whether the unlawful construction of a very large dam on Kangaroo Island should be reversed and the native vegetation reinstated. They were some of the matters that we heard. We also had I also heard criminal proceedings in matters that involve pollution where fish had been killed and other species of flora and fauna. I was fortunate to learn so much on the court, listening to expert witnesses and sitting with specialists from the various fields of natural resources and other areas, and also having the opportunity to learn from my Aboriginal colleagues in native title what being one with the land actually meant. So it was a time of learning for me, as well as a time of other things. And then I retired from the court. My world changed when I went as an Australian international volunteer to Fiji. I developed some wonderful new insights into the biodiversity of flora and fauna species in the tropical world. I was a volunteer with the Oceania Regional Office of the International Union for the Conservation of Nature. IUCN, in case you don't know it, is an international NGO. It's recognised globally as an international organisation recognised by the UN, as well as the countries of the world. Its mission is a just world that values and conserves nature. I went there in late 2010 and stayed until early 2013. While I was there, I worked not just in Fiji, but in a number of Pacific Island nations. I do recall the excitement for me of attending the Pacific Islands roundtables for nature conservation in 2011, 2012 with NGOs, environmental NGOs, conservation NGOs from across the Pacific, and also attending the inaugural Pacific Islands Species Forum in Honiara, Solomon Islands, in 2012, where I was thrilled to hear from scientists of their knowledge of new discoveries, new knowledge of known species, and of efforts at using traditional knowledge to protect biological diversity. I was also awed by the amount that we still don't know about species and the appalling rate of destruction of species all over the world in the Pacific, as well as Australia. Australia's very bad, but it's bad everywhere. In my time with IUCN, I had input into a range of measures. I should say, when I went as a volunteer, I was sort of given to understand, not specifically by anyone in particular, but that it would be, a bit of an easy year. but it wasn't. I worked very hard. I worked long hours, so I had a lot to do. Anyway, I had a great time. I had input into a lot of measures and projects directed at protecting species, at better managing the natural environment and addressing climate change. Some of these were enforcement within the system of locally managed marine areas, training enforcement officers, raising awareness and understanding of environmental impact assessment, improving the resilience of coastal and marine ecosystems to climate change through law, protecting mangrove ecosystems to increase the resilience to climate change and protect fish species. Mangroves are also wonderful sequesters of carbon. Establishing integrated river catchment management in the Nandi River Basin in Fiji, working on a protected area management agreement with Conservation International and the Fiji government for the Sovi River Basin, and writing a report on carbon rights in the Fiji context as part of a REDD+ scheme, which stands for Reducing Emissions from Deforestation and Forest Degradation and Fostering Conservation, etc., in the forest, in respect of natural forests. So I wrote a background report on carbon rights as a prelude to setting up a REDD+ project in Fiji as part of an approach to climate change across the Pacific area. So other countries were doing similar things. As well, I worked with other NGOs in the biodiversity conservation areas, such as the World Wildlife Fund, Conservation International, and the National Trust of Fiji. I had access also to international experts in IUCN headquarters in Switzerland and elsewhere, in particular IUCN people in Bangkok. So I had a lot of discussions about protected areas, species, and natural resources. These are just some of the things I came to understand in my time with IUCN. And by the way, I volunteered there 2010 to the end of 2011. And then I volunteered to go back as an officer with IUCN for another year until early 2013, working as the senior environmental law officer in Fiji, based in Fiji. So some of the things I came to understand that I hadn't really come across before: the significance of the IUCN Red List and how it's compiled. That looks at the whole hierarchy of threatened, endangered, vulnerable species. The categories of protected areas set out in the IUCN guidelines for protected areas legislation. The threat posed to biodiversity from invasive species. I hadn't really realised the role of invasive species. The necessity of a human rights approach and drawing on customary law and leadership for the protection of biodiversity. The value in establishing locally marine managed areas managed according to traditional principles. The issue of Indigenous intellectual property rights and access and benefit sharing. The importance of valuing ecosystem management and an understanding of the concept of payment for ecosystem services. And the threats to biodiversity, known and unknown, posed by seabed minerals exploration and mining, attractive though it is to the low income and resource poor Pacific Island nations. Then I returned to Australia, and since 2013, for a period of 5 years, I was with University College London campus in Adelaide. Well, I did get to London from time to time, educating younger people UCL master's degree students in environmental and energy law and natural resources governance. I'm still doing lectures once a year in the natural resources governance course in relation to law, human rights, and working with Indigenous communities, particularly educating around free, prior and informed consent as part of the social licensing unit within the natural resources course. As the professor responsible for the operation of the Australian campus of UCL reminded me when I started there in 2013, we are all global citizens. Being a global citizen means understanding the challenges our world faces and contributing to the solutions. Our first responsibility is to live in harmony with the environment.
That's great. Thank you, Christine. That was a really, really good presentation. I think a round of applause from everybody there. That was such an interesting history, and I think we just scratched the surface today, and I'm sure that there will be little anecdotes and stories of different elements which you've actually seen happen over time, because you've been at the basis of a lot of the environmental law when it sort of really took off. It must be quite difficult for you to have seen how far we've come now and how far we've yet to go to get the balance that we need.
Particularly when I hear from people like Alana, what's happening in the forests of Victoria, yes.
Were there any questions quickly? We only have a minute for questions. Were there any there? Suzanne?
Christine, have you come across any situations with Indigenous women and land rights? I'm just thinking that there's a situation in South Australia near Hawker where they wanted to put a nuclear waste dump, government wanted to put a nuclear waste dump, and everybody approved it, basically except the Indigenous women whose land it was on. Have you heard anything about that one? And anyway, they finally, I think, it's going to be moved to Kimber, which is probably not great for them either. But that seems to me a really big issue that a lot of people don't really know about now, is that Indigenous land rights, and actually the women's land is different from the men's land, and the men are often asked, you know, if they will agree to it being used for whatever. They say yes, and the government thinks they've got permission.
Mm. Yes, look, it's not, I haven't been involved in, nor do I know a lot about the situation in Hawker you referred to, but I'll just mention one example of that. When I was in Fiji, there was a mine proposed for a big valley just up northeast of Suva in Fiji in the mountains. The mining company said it had consulted as part of its EIA with the landowners, but they hadn't. What they had consulted with were the men and not the women. And the women came to, I was very much involved with the Fiji Environmental Law Association, and the women came and talked to us and said, we haven't had a say, we have not had an opportunity. Yes, the landowner, you're quite right. Across many places, PNG is one I can think of too, where it's in some areas, it is the women, the land runs through the maternal line. It's not the appropriate terminology, but yeah, there's been a failure, you know, also in the Pacific, there's a bit of a big man culture. And there's a failure to consult women. So it's happening, it happens everywhere. It's unfortunate and it needs to be redressed, but yes, I am familiar with those situations.
Wow.
What we do about it, we just have to keep asking the questions. Have you talked to the women? How long we have to go on doing it, I don't know. We've been doing it for a long, long time, and still people fail to consult with the women.
I think that'll be our take-home message, you know, keep asking, have you talked to the women? I think that's a great point to move on from. Thank you, Christine, that was great.